Welcome to Pass the Torch of Liberty. Our goal in this course is to help you understand the foundations of American liberty and to pass that understanding on to others in your circle of influence. This is Lesson 5, Constitutional Government. In previous lessons, we have discussed the foundations of ordered liberty, the golden triangle that describes the social contract of citizens with their government. Today, we examine the structures of American government that were designed to protect citizens from tyranny. And we will discuss modern challenges that undermine and threaten to destroy the constitutional system of government. It is for us and for each generation of Americans to answer the question posed by Alexander Hamilton in the opening of Federalist I, whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. History is mostly a story of rule by force and fraud. He who had the power made the rules. Countries were ruled by kings and emperors and military conquerors. America was the first country in history to create a successful democracy, a rule by the people. Many countries have copied the American formula with varying success. Some countries, such as Russia, have the appearance of democratic rule with a parliament and system of courts, but are in fact ruled by a single party that is controlled by a few powerful men. In practice, they are more like dictatorships. The idea of the rule of law, that the government as well as the governed are equally subject to the law, became encoded in the English Magna Carta in 1215. By the 17th century, it became understood that the king himself was subject to the law. Thomas Paine expressed this for Americans in his popular little book, Common Sense. In America, the law is king. For as absolute governments, the king is law, so in free countries, the law ought to be king, and there ought be no other. John Adams wrote succinctly in the Massachusetts Constitution that it should be a government of laws, not of men. The application is clear. The Constitution is the supreme law of the land. No one is exempt. The law applies equally to every person of every social status, race, ethnicity, and religion, to the poor and the very wealthy alike, and especially to the people in power, the President, Supreme Court, and members of Congress. In fact, each of them swear to uphold the Constitution. Federal, state, and municipal laws are subject to the Constitution as the final authority. The Constitution is our ultimate protection against tyranny, whether by one powerful ruler or by a few. No one can be allowed to subvert the Constitution. It is the supreme law of the land. The founders created a representative government in which elected representatives of the people enact laws. They carefully avoided a pure democracy in which the majority vote of the people would rule. Hamilton wrote of the horror and disgust he felt of the constant back and forth between tyranny and anarchy that dominated the history of what he called the petty republics of Greece and Rome. Madison wrote of the tendency in man towards a tyranny of the majority. This occurs when a majority, aroused by passion or common interest, pursue ends that are adverse to the rights of other citizens or to the permanent interests of the community. They saw tyranny as the inevitable result of a pure democracy which operates solely by majority rule. The Constitution is remarkable. Handwritten on 5 pieces of parchment, it is written in straightforward language that can be understood by all. It addresses perennial problems of governments. It defines our nation. It protects our citizens, and it formally constitutes the American people. Their challenge was to secure the rights and liberties promised in the Declaration of Independence, preserving a republican form of government that reflected the consent of the governed, yet avoid despotism on the one hand and the tyranny of the majority on the other. The system that they created was based on a distribution of power to prevent any one person or group from dominating the government and also on a separation of duties and responsibilities. First, they limited the federal government to certain specified functions distributed among 3 branches of government, and they left everything else to state and local governments. There was a balance of power between state and federal, the first protection against an all-powerful federal government. In the early days of the Republic, states were very diverse and were much more powerful than today. Second, they distributed power between Congress, the President, and the courts. In a nation ruled by law, the founders designed a system of checks and balances in which no one body can dominate the others. Each body has its own interests and can restrain others when they feel it is necessary. Congress, as the first among equals of the 3 branches of government, was most representative of the people and embodied the very essence of governing because it alone had the authority to make laws. First among equals means that everything starts with Congress passing laws. The people, through their elected representatives, make the laws, and everyone, including the President and the courts, must submit to the rule of law, laws enacted by Congress. The President can veto these laws, and Congress can override the veto. He is responsible and accountable to Congress and the people to enforce these laws. The Supreme Court ensures that the laws of Congress conform to the Constitution. They can overturn laws, but only if the law does not conform to the Constitution. The Constitution defined enumerated powers, simply a list of powers, for each branch. Among the most important powers delegated to Congress were the ability to tax and borrow, to regulate commerce, currency, post offices, patents, federal courts, the military, and to declare war. The founders clearly intended all other legislative authority to reside with state and local governments. The most difficult issue faced by the Constitutional Convention was how to define the executive branch, the President. They were keenly aware of tyranny by Caesars, kings, and military dictators. On the other hand, they realized, having just emerged from a long and costly war, that a strong executive branch was needed. Ultimately, they were confident in defining executive powers as they did because of the widespread assumption that George Washington would hold the office. Delegate Pierce Butler observed that many members cast their eyes towards General Washington as president and shaped their ideas of powers to be given to a president by their opinions of his virtue. This assumption permitted them to define a stronger presidency because they trusted Washington to set a strong precedent of integrity and virtue for the office. While the president has executive powers to direct the nation's affairs, a very broad power, his powers with respect to legislation are limited to recommending bills to Congress and the veto power. The president is charged with ensuring that the laws are faithfully executed. He appoints justices and ambassadors with the consent of the Senate. He is the commander-in-chief of the armed services, yet he cannot declare war. That's the prerogative of Congress. The president's powers are granted by the authority of the Constitution, not by Congress or by the courts. Here we see several mechanisms built into the Constitution that distribute power to pit one power against another in order to minimize the threat of tyranny. The framers understood the principle that power corrupts, and absolute power corrupts absolutely. The distribution of power is to prevent tyranny, as by a powerful president that would disregard Congress or the courts or the Constitution. The independent court system was another innovation. John Adams wrote that the dignity and stability of government in all its branches, the morals of the people, and every blessing of society depends so much upon an upright and skillful administration of justice that the judicial power ought to be distinct from both the legislative and executive and independent upon both, so that it may be a check upon both, as both should be checks upon that. An independent judiciary is vitally important to uphold the law and apply it fairly and impartially. As the Constitution asserts itself to be the supreme law of the land, it is the first duty of the courts to ensure that the Constitution enforced fairly and impartially. We have described the United States not as a pure democracy, rather a representative democracy, a republic. The consequence of representation is to filter democratic opinion so that the cool and deliberate sense of the community rules rather than every sudden breeze of passion. It was designed to be hard work, to be deliberate, to have civil debate on big issues, resulting not only in fair and just laws, but engaging the public in the process and elevating them when required to a refined and enlarged public view. They saw that it would be tyrannical to try to force everyone to have the same opinions, passions, and interests. Matthew Spalding wrote, "The solution of the men who wrote the Constitution, famously laid out in the Federalist, was to control the political effects of these differences and thwart the formation of unjust majorities while celebrating the natural diversity inherent in human liberty." The Progressive Era from 1890 to 1920 began to challenge traditional thinking about the foundations of American liberty. Fueled by Darwinian evolution and the notion of human progress, progressives, including Presidents Teddy Roosevelt and Woodrow Wilson, championed the science of eugenics with the goal of eliminating human disabilities and undesirable races through genetic engineering. Only when the end result of eugenics was revealed in Nazi death camps did that idea lose popular support. Progressives rejected the very idea of permanent principles, of a transcendent moral law, for example. They rejected the idea of natural rights as a meaningless idea, and that led to rejecting the whole American political tradition as meaningless or not applicable to modern society. There are no inherent or inalienable rights common to all mankind. Rather, rights are granted by the government. Woodrow Wilson described the progressive movement's desire to interpret the Constitution according to the Darwinian principle. Since rights are, in their view, granted by the government, the Supreme Court has been very busy creating new rights to satisfy populist demands. Further, progressives rejected the notion of limited government in favor of unlimited government. The new task of government was to be the instigator of change rather than limited to the functions enumerated by the founders. Progressives succeeded in passing the constitutional amendment allowing direct election of senators rather than being appointed by and responsible to the state legislatures, which greatly reduced the power of the state legislators and, of course, increased the power of the federal government. Progressives introduced the administrative state. By that we mean the many departments and agencies of the executive branch. Americans are today ruled by a vast army of unelected bureaucrats that work in agencies such as the FCC, SEC, OSHA, IRS, and so on. These unelected bureaucrats issue and enforce regulations that have the force of law with little or no congressional oversight. In effect, Congress has passed the buck to the bureaucrats. Obamacare is the latest example of a massive legislation that created a massive bureaucracy empowered in many ways to create its own rules. The denial of human nature as the foundation of equal rights led not only to the idea of rights as a benefit provided by the government, but a change in the meaning of equality from equality of persons under the law to equality of outcome. From Franklin Roosevelt's Catalog of Rights to Lyndon Johnson's Great Society, the federal government was transformed into what's been called a nanny state that attempts to provide equality of outcome to citizens. Inherent in this is not only the welfare state, Social Security, Medicare, Medicaid, redistribution of income through tax policy, but also claims for free college education and free childcare. In order to implement their philosophy, they developed a plan to fundamentally transform America. They would disseminate secular knowledge and minimize the effect of religion through controlling the educational system. They centralized politics under the national government in order to remove control from ordinary citizens and give it to, quote, the intelligent, far-sighted, and public-spirited elements of society. The very idea of self-government had to be weakened and overcome, replaced by government-created and government-directed national education. In the progressive view, there is little reason to worry about moral character because popular opinion will be guided by progressive political leaders and public policy administered by apolitical experts. Traditional virtues are replaced by faith in the government and in the inspired vision of political leaders. Matthew Spalding wrote, "Liberty is no longer the freedom of self-government in the context of constitutional order and the institutions of civil society, such as the family, church, and civic groups, but it becomes the autonomous pursuit of personal self-realization within the horizon of national social ideals." Spalding continues, "For progressives, the role of the judiciary is to adapt the law and deconstruct the Constitution to bring American society forward according to judges' view of societal change. In this world, the Constitution is an empty vessel. It means whatever judges say it does, according to their personal speculations, which is to say that it means anything or nothing." You are probably aware of the battle for the Supreme Court between progressives, as we have just described, and constitutionalists, sometimes called strict constitutionalists, who side with the founders, who believe that the proper role of the courts is to apply the Constitution according to its original meaning and not ignore it or rewrite it as a so-called living document. Thus, the constitutional challenge of our time is a battle between opposing worldviews. Progressives deny fixed principles, including the claim that in the Declaration of Independence that all men are created equal, that they are endowed by their Creator with certain unalienable rights. They think that all ideas are relative and that rights are given by the federal government. Progressives think that the Constitution is a living document, is not binding on us today, and we can reinterpret it however we please. The result is not the rule of law, but the rule of men, specifically that 9 Supreme Court justices determine social policy. Constitutionalists believe in and attempt to follow the enduring principles described in the Constitution and in the Declaration of Independence. They believe in an objective moral code that is binding upon all men everywhere. They respect the Constitution as the supreme law of the land, as the authors intended it should be. With the founders, they believe that social and moral issues are best decided by the people through the legislative processes, not by unelected judges. Constitutionalists believe that this is essential to the rule of law, and I think the founders would all agree. In the next lesson, we will discuss the press and the media. What are the requirements of the press in a society of free people? How does the media influence public opinion, morality, and our relationship with our government? What about fake news? What about propaganda? These are our subjects next time. Please refer to our website for discussion materials and additional reading on this topic.